Hi, my name is Melissa Garcia, and I'm an attorney with Hyman Sanchez in the transactional department. And today I wanted to talk to you about how homeowners get to vote by mail or otherwise outside of a meeting. So this is something that comes up quite a bit in our practice, that for whatever reason the associations don't want to hold a meeting and they're going to be conducting a vote by mail or outside of a meeting. I wanted to explain the process for doing that. First of all, you should probably know that pretty much anything can be voted on outside of a meeting by mail or otherwise by written ballot. This is something that is provided by statute. Colorado law says, unless otherwise provided in your bylaws, any action that you can take at a meeting, at a regular or special meeting of the homeowners, can be taken by written ballot outside of a meeting. So, there's a lot of things that homeowners vote on, election of directors, amending the governing documents. You can do that. But I guess the question you should ask yourself first is whether you should conduct a vote outside of a meeting. At a meeting, for example, if you're electing directors, it would probably be better to be able to speak to the candidates and meet them face to face rather than reading about their statement of candidacy in whatever mailing package that you provide. Or if you're going to, for example, levy a special assessment and you want homeowners to vote on that, it would probably be better and you would probably get more support if you were able to answer questions face to face and have that interaction and connection with the homeowners that you don't get via mail. But that aside, it's certainly you know your community and perhaps more homeowners are willing to respond by mail or not willing to attend a meeting, or maybe you've already had a meeting, an informational meeting, and now you're just conducting the formal vote. So if you get to the point where you decide you are going to conduct a vote by mail or by written ballot, then here are the things that you need to remember to do. So first of all, you need to make sure that your ballot and your cover letter include the information that is set forth by statute, and that's the Colorado Revised Nonprofit Corporation Act. And it prescribes a lot of different things that you have to include in that mailer. The first thing is the ballot itself has to state whatever the action is. So if you're voting on an amendment to the bylaws, it has to say this ballot is for the purpose of voting on an amendment to the bylaws. And it has to provide an opportunity for the homeowner to vote for or against that particular action. So you can't just submit a ballot that says vote for this action and leave out the vote against the action. Next, you need to include the percentage of approvals necessary to approve that proposed action. So for example, again, if you're amending your governing documents, there's a specific percentage of homeowner approval that'll be necessary to pass that action. You need to include that percentage. It doesn't say you have to actually state the number that equals that percentage, but it's always good to put that in there as well. Next, you need to include the number of responses necessary to meet quorum, because this is really like taking action at a meeting, but outside of a meeting. And at a meeting, you need to have enough people in person or by proxy to hold that action or to take that action. Same thing with voting by written ballot. You need to have enough homeowners respond and cast their vote with the mailer that the same quorum or the same number of homeowners have to respond by mail that you would have to have present in person or by proxy at a regular meeting. So whatever your quorum is, you need to include that in your mailer, both the cover letter and on the ballot, and state the number of homeowners necessary to meet that actual quorum. So if it's 20%, what's the number that equals 20%? Include that as well. Then you need to include information that is sufficient to permit whoever's going to be voting on that document to actually make an informed decision. Again, because you're not at a meeting, you want to provide as much information as if you were at a meeting so they could make an informed decision. That's the bottom line for that. Otherwise, they don't get to ask those questions that they would normally ask at a meeting. Most importantly, you need to include a deadline date and time by when the ballots need to be returned. And this is important because whatever deadline date and time that you state, you cannot count any ballots after that stated deadline. So if you have a large number of homeowners within your community, you need to make sure that you push back that deadline date far enough so that you're able to collect enough ballots to take action. So what I would suggest is you set the deadline date and you mark halfway between now and that deadline date of when you are going to collect, or I'm sorry, you're going to count the ballots, so that you know, okay, we're halfway through that deadline time frame, and now we have this amount of time to go and collect the rest of those ballots. So you make a big push at the latter part of that time frame. So on a final note, either have your attorney prepare this. You really ought to do that because it's a legal document. Have your attorney prepare it, but if you're going to prepare it as a board, then make sure that your attorney reviews it, because you certainly don't want to spend the time, the effort, and the money and that comes with mailing all this stuff out and then find out later you did it wrong and you have to start all over again. It's better to just do it right the first time, so make sure your attorney reviews that. So for more information on other HOA topics, make sure you look at our website and check out some of our educational forums coming up. Thank you so much.